So when this is really important, actually, we have to be able to change status in the United States. You have to have essentially have an existing status. So if you had a tourist visa, it expires, and then you want to go and change status to a student visa, an L1, H1B, whatever. That's not going to work because you're out of status. You have to be maintaining the underlying status that you have there. Um, However, sometimes you might have a case where you person comes on a B1, B2, and then requests an extension of B1, B2, and after that decides to do an E2 and L1 or F1 or H1B or something like that. And what happens, typically my policy was like not to do that because even though you have filed like an extension of status, doesn't mean you have the underlying status. So if you then file for another change of status, then that's not going to work. And I had colleagues say they've been doing this okay. Another colleague recently posted on somewhere that they had a case where they did a B1, B2 extension while it was pending. They made a change of status request for, I think, an L1 or some sort of work visa. And initially it was denied by USCIS, saying you didn't have the underlying status to be able to change status. And then he filed a lawsuit for USCIS, like delay in the process for approving the B1, B2 extension. And that delay, a government delay, caused them not to have the status that they wanted. And one thing when you do these lawsuits, that they somehow miraculously cases would get reopened and approved, and that happened there. So ideally, I wouldn't want to do this to even get to that, especially filing a lawsuit. Not every client's going to want to do that. But I've had several colleagues. Again, I try to avoid this situation as much as possible. But I've had several colleagues say they haven't been able to do this. Now there is a context that pops up, and I do so many videos on this topic that I get a lot of people contacting me about it, which is when you have an asylum case pending. Like you file it while you have like a valid B1, B2. If B1 expires, you have asylum pending for years, and then you file for adjustment of status. The argument is that were it not for the government delay, you would have some sort of status already. It would have been okay, this and that. But what we're seeing is almost like vast majority of USCIS officers are now denying adjustment cases if someone just has asylum pending as their immigration quote unquote status, not really status. And this matter of LK, which a lot of lawyers cite, doesn't really speak to that. It's kind of this weird, this nonsensical decision, in my opinion, that says if you have your affirmative asylum interview and it's denied, then you're out of status and you have to go to immigration court. You can't change. But that's kind of obvious. Like, yeah, at that point, there's made a decision. What if it's pending? So I'm about to sneeze and I got getting allergies. It's fall. Why would I have allergies now? I have them in spring, but somehow the last couple of days I had allergies, itchy throat, runny nose. So annoying. And so, sorry, I'm complaining a lot, but I thought it may be funnier to complain. It's like one of those joke kind of things. Okay, so let's see. So that's an important thing to keep in mind. If you really have to do it, change of status after filing an extension, you might as well sue them. Prepare the client for a lawsuit that's something like that's going to be possible.